This is meeting number 25 of the House of Commons Standing Committee on Public Safety and National Security. Before we continue the clause-by-clause consideration, I would ask the committee to consider the budget that the clerk distributed yesterday morning. Members will recall that the committee had already adopted a budget for the consideration of Bill C-8, but unfortunately that budget did not provide for enough meetings for this bill. This budget, therefore, seeks additional funds to cover the cost of the additional meetings for a total of $4,500. Please note that these amounts are estimates and the committee may spend less on the study. Any funds not spent by the committee will be returned to the liaison committee. Is it the committee's pleasure to approve this budget? I understand that the answer is yes. Very well. The budget is carried. Pursuant to the House Order of October 3rd, 2025, our committee is meeting as part of its consideration of Bill C-8, an act respecting cybersecurity, amending the Telecommunications Act, and making consequential amendments to other acts. I would now like to welcome our witnesses who will be answering our questions as necessary. From the Department of Public Safety and Emergency Preparedness, Mr. Richard Bilodeau, Senior Assistant Deputy Minister, and Ms. Kelly Ann Gibson, Director of the National Cybersecurity Branch. From the Department of Industry, Andre Arbour, Director General, Wen Quan, Director General, Stephen Bolton from Strategic Policy, Director General, and Richard Larose, Senior Cybersecurity Advisor. Our 6 witnesses are seated at the table with us today. We will now proceed to the clause-by-clause consideration of the bill. With all of that said, at our last meeting, we concluded with Amendment CPC, or rather BQ7, which brings us to CPC 36. However, there has been a notice of motion for BQ 7.1. Would you like to move this motion, Ms. de Bellefeuille? Yes, Mr. Chair. I would like to present my amendment. It is a little tardy, but still important. What it does is to protect whistleblowers, to stop them from being reprimanded or accused, or from their identities from being disclosed. So this is to protect them under the Act. It is to protect our whistleblowers. I believe it is something that we might have forgotten in analyzing this bill now that we are arriving at the end. I think it's important to support those people who share information to help us protect our systems. I think we need to protect their identities when they provide information. I think that makes sense, and I'm not sure if my colleagues share my feeling that this was missing from C8. Very well, thank you. Since this amendment has just now been tabled, I will suspend for a few moments. This will allow committee members to be sure that they have properly understood the amendment, but we will take just a few moments. So I would invite you to stay close to the table and we will be reconvening.
La séance.
I call the meeting back to order. We will now begin debate on this new amendment, BQ 7.1. Mr. Ramsey. Yes, I have a question for Mr. Arbour. In English, if he prefers, or in French. Could you please comment on this new proposed amendment?
Merci, Monsieur le.
Thank you for the question, Mr. Chair.
Il y a déjà des protections.
There are already protections around personal information under the Privacy Act and other protections that have been adopted through other amendments as part of the study of this bill. So there are protections that already exist. As for the text of this amendment, there are a number of difficulties related to the drafting. 3 in particular. Firstly, in my opinion, there is confusion between the terms person and individual. In a legal context, the word person has a broader meaning than individual. It could also include corporations. So we're talking about the Telecommunications Act here and the broader impact of there are implications for the CRTC and for Industry Canada. So that is the second point. Now, thirdly, we have consultations where voluntarily disclosed information is a regular occurrence. And this provision would actually create a conflict in that context. On the one hand, an individual provides certain information in the context of public consultation, the names of individuals. But if we look at this text, it would be impossible to share or to publish that information, even if it's as part of a public consultation. Or there are also other situations where a person might provide us with information. If it is very important here for us to find a solution, then perhaps we can find a way around problems in these contexts, and we could do that by replacing the term person with individual.
Our own initiative to the ministre, au ministre, et dans le contexte légal, le ministre.
To the minister, and here the word minister would also be synonymous with ISED, but also, in my opinion, there should be a direct request to be for confidentiality.
Parce que si l'individu.
Because if the individual in question does not have an interest in confidentiality, for example, if it's during a public meeting, there could be a conflict in the act.
Madame de Bellefeuille, pardon.
Ms. de Bellefeuille. So here's what I understand. In the wording, well, the objective of what I'm trying to do is to protect whistleblowers So what you're telling me is that they already are protected. This might not be necessary, therefore, but if I did want to have it adopted, I should replace the term person by the term individual. Is that correct? Yes. So every time the word person is used, it should be replaced by individual. Is that what you mean? Not in the first instance. So here, the identity of any person who provided, so on that line it should be replaced by individual, who provided information on their own initiative to the minister to achieve the objectives, etc.
Confidentiality qui a demandé.
And at the end, who has requested confidentiality.
Alors, Monsieur le Président, je sais.
So, Mr. Chair, I am listening carefully to Mr. Arbour's recommendations. I'm not able to sub-amend my own motion, so either my colleagues sub-amend it or we will move to a vote. It depends on how you want to handle this. There are a number of options. The first is to ask for unanimous consent to withdraw it and to submit a second motion. The second option is that committee members propose a sub-amendment, which they are invited to do if they wish. And third option is to vote immediately on your amendment. So, Mr. Caputo.
Thank you, Mr. Chair. I was just going to suggest the UC option.
Voyons s'il y a un consentement unanime pour retirer la motion BQ 7.
Is there unanimous consent to withdraw BQ Amendment 7.1? Yes. So there is unanimous consent to withdraw BQ 7.1. An amendment can always be tabled without advance notice, so that means that you are free, Ms. Bellefeuille, to submit another. Ms. Bellefeuille, yes, if the committee agrees, I will incorporate Mr. Arbour's recommendations into the motion which was tabled. That means I will replace the word person with individual where he indicated, and I will add when there is a request for confidentiality. So I'm not sure if our legal team has understood Mr. Arbour's recommendations, but that will be the essence of my new amendment. We're going to suspend for a few moments to make sure that the legislative clerks have taken due note of what has been proposed.
On va redébuter.
We're going to start the sitting again. Following some good advice from Ms. de Bellefeuille, she said that we can skip over to other amendments as long as they don't depend on BQ 7.1. And we are just waiting on the official translation of the new version of BQ 7.1. This brings us to Amendment CPC 36. Is Amendment CPC 36 proposed?
Thank you, Mr. Chair. I do move CPC 36. No requirement to state the number of times an order was made respecting confidential information. Thank you.
Très bien. Y a-t-il des interventions sur CPC?
Very well. Would anyone like
Ramsey?
Mr. Ramsey? Mr. Chair, it is our humble impression that this amendment could cause some confusion. There is information that is not particularly important or useful. There's a certain line here, the basis of information that was designated as confidential. So we're thinking about the implications that that wording would have and the usefulness of the information. If they are financial or operational data or information from the service providers. In any case, the order would be made, amended, or revoked on the basis of information that is designated confidential or non-confidential. So for that reason, we will be voting against. Thank you. Are there any other interventions? We will therefore move to a vote. Is CPC 36 carried?
Ma lecture de la salle est que...
I read the room, and I am seeing that CPC 36 is defeated, which brings us to Amendment BQ8. Is it moved?
Oui,
Yes, Mr. Chair. I would like to present BQ8. I believe the wording is clear. I think it's important that the minister publish a summary of the report on the website of the Department of Industry within 10 days after the day on which it is tabled in both houses of Parliament. This is in the interest of transparency, and I wish to have my colleagues' support on this. Thank you. Ms. de Bellefeuille, would anyone like to take the floor on this amendment? Amendment BQ8. Is it carried? Carried. Amendment CPC 37. Would anyone like to move it?
I will so move, Mr. Chair.
Merci, Monsieur le député Caputo.
Thank you, Mr. Caputo. Debate on Amendment CPC 37.
Monsieur Ramsey.
Oui,
Mr. Ramsey. The requirements relative to this amendment, giving a copy of the report, they are already part of Bill C8. They have already been covered. So if there were to be a second annual report that would have to be required, that would be an unnecessary burden for the department. Apart from that, I don't think this refers to any information that will enable us to better manage or apply the bill, so we will vote against the amendment. Thank you, Mr. Ramsey.
Thank you. If I could just ask the officials whether this is a redundancy, that obviously isn't the intent.
Thank you, Mr. Chair, for the question. It does specify preparing a report, and it seems to be a distinct report from the already fairly detailed reporting requirements that were adopted across parties as part of C26 and that were carried forward. So this is adding a second annual report.
Merci, Monsieur Arbour. D'autres?
Thank you, Mr. Arbour. Would anyone else like to take the floor? Does Amendment CPC 37 carry?
Il est rejeté.
It is defeated based on my reading of the room. So Amendment CPC 37 is defeated. Next, Amendment PV10 is deemed moved. Debate on Amendment PV10.
L'amendement PV. Oui, Monsieur Caputo.
Yes, Mr. Caputo.
Thank you. I know that CPC2 has changed a number of things. Given that, is this amendment necessary with respect to what we're trying to achieve here?
Thank you, Mr. Chair, for the question. No, it is not at all necessary, and for that reason actually creates confusion. So there is the right enumerated here already exists under the Federal Courts Act. Duplicating that in this bill creates confusion because it creates the impression that for the sections that or other contexts that don't explicitly refer to this right, you're giving the impression that you imply that that right shouldn't exist. It's best to avoid that type of confusion and rely on the existing law, which absolutely already exists under the Federal Courts Act.
L'amendement PV10 est-il adopté?
Does PV10 carry? No. PV10 is defeated. Amendment CPC 38. Would you like to move this amendment?
Député Caputo.
Mr. Caputo.
Move this amendment to permit what is often called an amicus curiae, which is literally translates to friend of the court for people who are unrepresented. The role of an amicus is to assist, not necessarily assist the court, not necessarily to advocate. Thank you.
Merci, Monsieur le député Caputo.
Thank you, Mr. Caputo. Mr. Ramsey. Look, once again, yes, of course, amicus curiae, but it is already covered the fact that before any federal court in the country, an amicus curiae can be appointed, so this is simply redundant.
C'est Monsieur
Thank you, Mr. Ramsey.
L'amendement CPC 38
Is Amendment CPC 38 carried?
Is that the case?
Thank you, Mr. Chair, for the question. Yes, indeed, it's the same situation as with the federal court amendment that we just had.
Then I'll seek you to withdraw. Thank you.
Y a-t-il un consentement unanime pour retirer l'amendement?
Is there unanimous consent to withdraw the amendment? The amendment is therefore withdrawn. Amendment CPC 38, is it moved?
I believe that's CPC 39 I'm seeking to move,
Point,
please.
c'est bien ça. L'amendement CPC 38 est retiré.
So CPC 38 is withdrawn. So we move to CPC 38.1. Is this amendment moved?
Point 1, is that amendment moved?
Yes, please, Mr. Chair.
Thank you. Debate. Is CPC 38.1 adopted?
Non,
Oui, Monsieur le député Ramsey?
alors,
Yes, Mr. Ramsey. So here again, Mr. Chair, this is a redundant provision. The federal courts already have the authority to appoint a special counsel when there is confidential information that must be examined. There is no need to add a special consideration under the Telecommunications Act because it already exists.
Ramsey, Monsieur?
Thank you, Mr. Ramsey.
Withdraw then, thank you.
Yes, is there unanimous consent to withdraw the amendment CPC 38.1? Withdrawn. Turning to Article 2. L'article 2 est-il adopté? Là, on comprend que l'article 2 est...
Is it moved? So obviously Clause 2 was amended and sub-amended a number of times. We therefore now have an amended Clause 2. Is Clause 2 carried? Section 2. We will now just make an overall decision. Ms. de Bellefeuille? There was a BQ 8.1 that was tabled. Oh, yes, but 7.1 needs to be carried first. You're right, Ms. de Bellefeuille. We will have to debate 7.1 later. So we are not able to do this yet because we have not concluded BQ 7.1 yet.
Donc, la bonne nouvelle, c'est que nous avons...
So the good news is that we now do have the translation of BQ 7.1. Do we need to have a reminder of what this amendment aims to do? No. So is BQ 7.1 carried? Yes, BQ 7.1 carries, which concludes our consideration of Section 2. Does Section 2 carry?
Oh, it's called section or article? Clause, sorry. Clause 2, adopted. Madame de Bellefeuille, vous avez une...
Ms. de Bellefeuille? I beg your pardon. I'm a bit confused. So does BQ 8.1 become 2.1? So we had discussed this a bit earlier. It's between Clause 2 and 3. Okay, perfect. So before we move on to Clause 3, we will add in your BQ amendment. So is Clause 2 carried? Yes, Clause 2 is carried, which brings us next to BQ 8.1. Would you like to move BQ 8.1, Ms. de Bellefeuille? Yes. When we were doing a clause-by-clause consideration, we also continued to have meetings with partners, and sincerely, I was wondering how I could enhance the bill to try to limit what I would say something that is it detracts from security. So we have internet providers in Canada who have subcontracted their infrastructure, all of their internet infrastructure, even the design, to foreign entities. So there's a company, which I will not name, for example, that subcontracted to an entity in India. So India is now responsible for managing all of the infrastructure of this internet provider, which means that if there were a problem with a cell phone tower, in order for it to be repaired, a worker who works in India would have to push the on button in order for repairs to be possible. So that led me to wonder how our information is protected, since these workers are in a different country that has its own rules. And on top of that, that is a country that has been documented to have spied on Canada. So how can we, should we stop internet providers from sending out their subcontracting work to other countries like India, even when we know all the risks in India? And another example, infrastructure was managed by subcontractors in Egypt for another company. And in Egypt, the data can be summoned because of the rules in Egypt. And I was wondering how that could possibly be. And Mr. Chair, I know that the Minister of Industry is aware of this and was unable to put a stop to those transactions because it was legal according to the rules, and because these companies want to make a maximum profit. So they're playing within the rules, but they're really pushing the limits. So I was wondering how I could limit the fallout from this when it comes to our internet infrastructure that is outside of Canada. And here is what the advisory committee proposed. It's not perfect, but it sheds light on the current problem we're seeing. And we know what a risk cyber attacks are. So we would ask our internet, or rather we're seeing that our internet providers are subcontracting to other countries and storing our data there. So Mr. Arbour, I was wondering how we can protect the confidentiality of our data when it might be being used in India or in Egypt because they are in possession of all of it. So I know that my proposal is not ideal, it's not perfect, but what I'm trying to do is to limit damage caused by this situation, and I think the government should have something to avoid the worst. And I think we need to look for a solution. So very humbly, I would propose this amendment, and it aims to mitigate risks. And I'm very much aware that it is not perfect, but it's better than nothing. I find the situation that I described very serious when we think of the fact that our data is being housed in India or in Egypt. And I don't want to name the two internet provider companies, but I'm sure you know them, these companies who have subcontracted out a part of their infrastructure. And Mr. Chair, even the design of their infrastructure was subcontracted out. So I hope that my amendment will be useful, even though I know that it won't be perfect, but I hope that it will help. Thank you, Ms. de Bellefeuille. Mr. Arbour, do you have any comment to make on that, or any other witness?
Merci, Monsieur le Président.
Thank you for the question, Chair.
D'abord, en ce qui concerne...
First, regarding these concerns, Bill C-8 already provides for the ability to have some control over procurement including foreign services. So there are already authorities that exist in the bill. It is not necessary to list out each specific risk. There's a framework under Part 1. And if the risk is real, then we do have the authority under C8 to impose rules on telecommunication service providers in Canada in order to control the supply chain. So this authority already exists in Bill C8. With the new 2.1 amendment, which has been moved, this amendment would add an extra consideration for the CRTC for a certain type of license, a license regarding international traffic, and the CRTC already has the obligation to look at that type of risk, so it's not necessary to add it here again. Furthermore, if it were added, it could lead to confusion around the CRTC and how it has to carry out its regulatory obligations. The CRTC has other authorities, for example, under Clause 24 for service providers. And that means that it's not necessary to be as specific as this because the CRTC already has other authorities. Also, there could be a risk of confusion that Parliament wants to limit the CRTC's authorities in this sense. But the good news is that there are currently authorities that already exist to fight against the situation that we're concerned about here.
Là, c'est que je vais vous le dire sincèrement,
I'll tell you honestly that I know the rules regarding the CRTC, but they're very minimal. So what assurance do we have that the infrastructure used by an internet service provider, if it is located in India, is secure? How can we be assured that our data is not being used? I know there are certain rules at the CRTC that have minimum thresholds or minimum requirements, but my question is, what power do we have to ensure that that information is not being used, given especially that these are countries that are documented to be problematic, and if they have our infrastructure, I'm not sure how protected they are by the rules at the CRTC. Thank you, Mr. Chair, for the question. Yes, of course, and that is the reason why Bill C8 exists. Of course, there are problems with the current telecommunications legislation, but C8 will add a new objective under Clause 7. This is a comprehensive clause to protect the telecommunications system. So yes, in the current act, there are gaps, and that is exactly the reason why the government has tabled Bill C8. There would be authorities for the minister and for the governor in council. The regulatory authority under C8 considers that ISED would be the primary regulatory authority to carry out the regulations, but there need to be authorities that exist, and currently there are not. It would only be under the comprehensive amendments in C8 that we would increase these authorities and that we would make it possible to impose mandatory regulations to protect the telecommunications network as well as data on that network. So that is the context. The protections exist. This amendment is an amendment to a certain type, a specific type of CRTC license. And that's the reason why I mentioned the CRTC, because it's involved in the context of this amendment.
Au niveau des principes,
The measures in C8 already has new powers to impose obligations on internet service providers to protect the network. And that is a very important thing to consider, especially for high-risk equipment. And what about abroad?
les règlements
The rules would be applied to internet service providers in Canada, but there are controls that exist for the supply chain. So we can take the example of Bell. They might be prohibited from purchasing a certain type of equipment or service. The obligation would be on the service provider in Canada, but it would be possible to control the supply chain globally, no matter the location. It could be a purchase of Canadian equipment, or it could be a purchase of foreign equipment or a foreign service. If there is a clear risk, because there are criteria around the risk, and the committee has added more control for us to have a safety net, but the framework does already exist. So it would already be possible to act if it was a valid risk. So that is a situation that exists no matter what the regulatory context is. It needs to be valid in order for a rule to be imposed on the industry. Very good. So, Mr. Chair, if I may, I would invite my colleagues to ask questions if they have any, and after that, I will make a decision as to whether I'm going to withdraw this amendment. Yes, Mr. Ramsey. To be very clear, Mr. Arbour, what Ms. de Bellefeuille is referring to is that there are a number of jobs that are subcontracted outside of the country. She referred to architecture and remote starting, because I've looked at the same example as she has, design, among other aspects that have been subcontracted, which can expose our telecommunications network. You're saying that this amendment, that 15(1)A would allow for telecommunications networks or all services, rather, the interpreter does not have a copy of the part being read. So all that to say, this amendment would cover any abuses in this context. Thank you for the question, Mr. Chair. There are a number of options with 15.1 or 15.2 in order to control or to limit that type of adverse activity if there were reason to believe that there was a real risk to Canadian telecommunications. Okay, thank you. Thank you, Mr. Ramsey. Other interventions? Yes, Mr. Au?
I also want to ask for clarification. Now, you're talking about probably after the fact, if something happened overseas and then we may be able to do something. So how can we prevent and protect in advance?
Thank you, Mr. Chair, for the question. So the powers under Part 1 of C8 would give the government the ability to implement regulatory controls on telecommunications service providers in the management of their infrastructure and services. And those can absolutely be preemptive. I keep going to high-risk vendor equipment because that's a tangible example that people are familiar with. But if there's credible information of a risk that a foreign equipment provider has risks associated with their equipment, 15.1 gives the government the ability to tell Bell, Rogers, TELUS, whomever, you can't buy that equipment from that vendor. Full stop, under no circumstances. It doesn't matter where the equipment is made. It can be made in another country, but the obligation applies, and it's more effective if the obligation applies on the corporation that's running the infrastructure in Canada, because they're under our jurisdiction. We can control them, via these powers. So we would say, you cannot use that equipment. Or we might have other mitigation measures that say only with these mitigation controls could you use that equipment. The same thing applies for the provision of services, and the text refers to services as well. And so the purchase of outsourcing is a purchase of a service from a foreign company, and so the same context would apply.
Merci, Madame de Bellefeuille.
Thank you, Ms. de Bellefeuille. I'm somewhat reassured. And I know that the amendment I'm moving is not perfect, so I would ask for unanimous consent to withdraw it, Mr. Chair. Thank you. Is there unanimous consent to withdraw the amendment? Yes, the amendment is therefore withdrawn. Is Clause 3 carried? Clause 3 is carried. Is Clause 4 carried? Clause 4 is carried. Is Clause 5 carried? Clause 5 is carried. Is Clause 6 carried? Clause 6 is carried. Now, we are reviewing Clause 7. A notice of amendment for CPC 39 has been tabled. Is CPC 39 moved?
Moving the amendment and asking the officials if they have any thoughts on it. Thank you.
Thank you, Mr. Chair, for the question. So this amendment amends the administrative monetary penalty authority with respect to individuals, and would add the word knowingly. So basically the I said, or the minister would have to prove intent before being able to fine an individual. This is an extraordinarily high bar to clear in a regulatory context. We are not an investigatory, like law enforcement body. Forcing us to engage in that type of investigation is not something that we are seeking to do. This would likely render the AMP's power basically unusable. And because the burden would be so high to try and demonstrate intent, there are already provisions that limit our ability to use the monetary penalty power in this case. There are criteria, such as the track record of the individual involved, the ability to pay, those types of things. It's already a much lower limit than the AMP's power for corporations. And there's a requirement that any AMP must be to promote compliance and not punish. If this were adopted to promote compliance, the main authority we'd have is the offense power, which is a very heavy power, like we're going after jail time or something like that. So the point of a monetary penalty is to have like an intermediate step that is not so drastic as that. I can continue if you have questions about how we've used AMPs to date. We don't use it often. There's been only 2 instances of individuals. We have 160,000 licenses, but I'll stop there.
Thank you.
Merci, Monsieur le député Lloyd.
Thank you. Mr. Lloyd, any debate? Is it CPC 39 carried? Amendment CPC 39 is defeated. Does Clause 7 carry? Clause 7 carries. Does Clause 8 carry? Clause 8 carries. Does Clause 9 carry? Clause 9 carries. Does Clause 10 carry? Clause 10 carries. We will now move to Clause 11, BQ 9. Ms. de Bellefeuille, Mr. Chair, this was drafted based on the Privacy Commissioner's testimony. And I think that we owe it to our commissioner to listen to their recommendations. I think they had a reasonable position regarding Bill C8. So I will wait to hear whether my colleagues agree with this motion.
Merci, Madame la...
Thank you, Ms. de Bellefeuille. Mr. Ramsey? Could we suspend for 2 moments, please? Yes, we can. We will suspend.
commençons.
We will begin the sitting again after a short suspension. Is there any debate on the amendment BQ9 rather? Mr. Ramsey. Yes, Mr. Chair. Pursuant to what was sent to the clerk, we would like to propose an amendment to the amendment. The reason for that is the following. We want to respect what has been moved in BQ9, and also we simply wish to ensure that it is in alignment with what's already in the Privacy Act. Would you like me to read the amendment? Do you already have it? It would be preferable to read the amendment. The interpreter does not have a copy. So Amendment BQ9, proposing to amend Clause 11 of Bill C and 8 be amended with what follows. C8 will be amended by adding after line 32 on page 22 B rather by adding after line 14 on page 31. There's a specification. This act will not change the provisions on the Privacy Act that have to do with personal information. Okay. Could we please confirm that this sub-amendment has been made known to the clerk? To the clerks, rather?
En fait, Monsieur le Président,
Mr. Chair, perhaps if Mr. Bellefeuille agrees, this sub-amendment could replace Amendment BQ9. So she would have to withdraw her amendment to allow us to table our own, of course, if she agrees. So there are two options. First of all, we'll ensure that the sub-amendment has been received and shared. That will take some time. And then we will see if there's unanimous consent to withdraw the amendment that was moved, B9. I can ask that now. Is there unanimous consent?
BQ9.
Interprétation, là. Mais j'ai compris quand même.
I understood. It is... I could say, I don't agree to withdraw my amendment on the fly. In any case, we will have to take a short break so that the legislative clerks can make sure they have the information that they need. They let me know a few moments ago that they don't have everything that they're going to require. So we will take a short break and we will come back very shortly.
Because we'll start as soon as we can. Rebonjour.
Hello again. We're going to do something we rarely do. In fact, we're going to need a motion to have Clause 11 stand so that we can come back to it later. And then we'll move on to 11.1 and the others. And this is going to give a chance to the legislative clerks and the other experts to look deeper into the content and how it could be interpreted, and also the difference between the different amendments to Clause 11. So can we let this stand? Do you move the fact that we should have this amendment stand? Does the committee wish to stand? And if you're listening to the interpretation, it means that when we let an amendment stand, we will come back to it later.
With that? Good. So we are standing Clause 11 and moving to Clause 11.1. Is Clause 11.1 adopted? Adopted on division. Is Clause 12 adopted? Clause 12 adopted on division. Est-ce que l'article 13 est adopté?
Is Clause 13 carried? Clause 13 is carried on division. Is Clause 14 carried? Clause 14 is carried on division. Is Clause 15 carried? Yes, on division. Is Clause 15.1 carried? On division. Is Clause 16 carried? On division. Very well. This brings us to the consideration of a possible new amendment. BQ 15 has been sent as a notice of motion. Would you like to move it, Mr. Bellefeuille? Yes, in fact, this is an amendment that will allow parliamentarians to come back to a new act. Bill C-8 has been a very long-awaited piece of legislation. There has been debate, and there were still some questions lingering on the way things should be done. So I think that it's useful, if we were to carry this piece of law, to be able to come back to it and review it every 5 years. I think that this would be wise. So I will ask for my colleagues' support, and this would make it necessary for the government to carry out a review of the new act after 5 years and to publish the report. Thank you, Mr. Bellefeuille. Mr. Ramsey? So we agree with the sentiment behind the 5-year review, but we have some reservations. So Ms. de Bellefeuille's amendment says that it should be the industry minister who undertakes the review, but this falls under the public safety file, so it should be up to the public safety minister to carry out that review. You already have a copy of the amendment. Let's start by you reading a sub-amendment. So for BQ 15 to be replaced by the following, that Bill C-8 be amended by adding after line 30, page 88, the new part that follows. So for the 5-year review, 15.1.1, 5 years after Clause 11 comes into force, the Minister of Public Safety and Emergency Preparedness undertake the review of the Act on essential cybersecurity systems. And there should be a report. And after the end of the review, the report with conclusions and measures that should be taken regarding this act, including infractions, and also including recommendations that have to do with amendments to the criminal code or other acts as necessary. And then for the third part of the report section, that report should be tabled in both houses of Parliament within 15 days after the end of the review.
Très bien. Écoutez, nous allons faire.
Very well. Look, we're going to suspend because the legislative clerks need to confirm some details, so we will suspend. Okay, so we are back. The teams worked very hard. But that said, given that there is a little confusion around the nature of the sub-amendment moved by Mr. Ramsey, but which is not a true sub-amendment, so it cannot be a sub-amendment to Amendment BQ 15. So instead, if I'm understanding, another sub-amendment will be moved for BQ 15. So that makes things a little more complicated, which means we will adjourn the meeting for today in order to do a few things. So we will look at a new clause 17 to be amended Thursday. And Thursday, we will probably also come back to clause 11. And there's a lot of work to be done between now and then to be able to do that. So before adjourning today, I would like to let you know that on March 10th, the Tuesday after the break week, the minister and his team will be here to discuss Supplementary Estimates C, and we will have the opportunity to discuss other activities for our wonderful committee at SECU.